We have 20 minutes, and you have 3 minutes to open and 2 minutes to close, and you may begin when you're ready.
Good morning, and as I'm sure you know, I'm Wesley Heidt, and before telling you a little bit of why I think I would be a good choice to serve on this court, I wanted to reference something that I'd said in my application, which talked about the respect I have for the court, and for all courts, and the judges that serve on the courts. And, to continue to get excellent judges, the way we do that is, we have conscientious people doing what you do, so thank you for what you do. What do I bring unique to this process? You have a lot of good applicants in front of you. You have, some tough choices here to make. I came out of law school and I had the opportunity to work as a staff attorney, working behind the scenes with the trial court, learning from those judges, learning from good judges, learning from some bad judges. You can learn from both. And then, ever since then, I've been with the Attorney General's office. And as an Assistant Attorney General, I think it's almost unparalleled the amount of appellate experience and opportunities that have been given to me. Within probably about a year of joining the office, I was arguing in the Florida Supreme Court. Here before this court, I've handled thousands of cases. There's not a day that goes by that I'm probably not filing some kind of pleading before this court. But beyond that, when you look at what happens with our office with the case that goes beyond this court, most attorneys have an appreciation that cases in this court have an effect below. What happens beyond? I've handled cases in the Florida Supreme Court. I've had the opportunity to argue up there numerous times, handled dozens and dozens of cases there, complex issues, difficult issues, first-degree murder cases, child sex battery cases, constitutionality of statute cases. But even beyond that, I've had the opportunity to argue in the Middle District and win cases in the federal court, seeing the big picture of how cases from this court fit. I've argued cases in the 11th Circuit. The Middle District declared Florida's drug statute unconstitutional. One of my writing samples would be where we appealed up to the 11th Circuit, so as appellant I got the Middle District reversed, and our drug statute is not unconstitutional. And I've handled cases up in the U.S. Supreme Court. So, it's been a amazing opportunity, a lot of experience in the appellate world. Since early 2008, I've also run one of the largest appellate offices in the state of Florida. We have 20 attorneys, about 10 staff, and we handle just a crazy volume of cases. Shepherding those cases through electronic filing here in the DCA system, the portal system, the Middle District system, the 11th Circuit system are all different. And I've helped, administrative office that does thousands of those kind of cases. So those type of abilities, those skill sets, I think would be unique and be an asset to this court.
Good morning. I had the honor of vetting your application. I want to tell you that all the folks I called to talk about you all thought you would get me out. Really, you have the highest standards of academic and legal ability. One of the concerns, first of all, I'll couch it in terms of one of the concerns of some folks that practice before the appellate court is that there is a strong need for people from private practice who've been in the trenches, who have done civil work. I noticed if I look through your resume, you've been mostly working for the government and doing, government appellate work. Is that accurate? And how would you respond to the group who would say the court really needs some private practice, complex civil, commercial litigator types?
Well, I've done some civil. Doing law school, I worked for a civil firm. I came out, and as a staff attorney, I did whatever the judges asked me to do, including some civil. I did about 10 years of civil forfeiture. No one brings every single thing to the process, but when you look at the court's volume, I think one reason they created this position is the caseload in the 5th District Court of Appeal and the number of judges. I think they have the highest case ratio for number of judges here. And the majority of the cases, about 3/4 of the cases that this court handles are criminal. And the majority of my experience is in criminal. And when you look at the judges that are currently here, many of them did come from a civil background. May not be the satisfaction of all civil lawyers, but when you look at the rules, when you look at an appellate proceeding and the standard of review and abuse of discretion, summary judgments, de novo review, these are things that I've done on a daily basis, be it in the criminal world or the civil world. You look at the appellate record, you take the input from the appellant and the appellee, you have to law clerks to help you, and you reach the right legal conclusion applying the statute, applying the case law. And that's the experience I have.
I have one other question.
Yes, sir.
In the sense where you sit, I think this is an important situation. There have been several decisions that have come down recently from all levels of courts, circuit, district, and the Supreme Court, taking the position that the legislature has overstepped its boundaries in creating legislation which has the effect of basically limiting plaintiffs' remedies and rights. For instance, the two courts have now declared the Florida workers' compensation law unconstitutional. One declared medical malpractice, parts of the medical malpractice unconstitutional. As on my reading is based on the due process rights and access to courts rights. Do you have a position on, have you ever had a chance to argue that, first of all? And second of all, what's your take on where that's going?
Admittedly, I'm not familiar with those cases. I've defended Florida legislation for 20 plus years.
Right.
That's one of the things we do as an assistant attorney general. That's what I did in the 11th Circuit. Statutes are presumptively constitutional. And that's a huge threshold, and I think it's something coming from my situation that I have a full appreciation for. The legislature in the criminal arena, when you look at the Florida statutes, library's changed since I was here last. When you look at the Florida statutes, a lot of them are criminal, a lot are civil, but the presumptions of correctness of these statutes and the application of that case law hasn't. Anytime the legislature changes, the courts are going to review it. Again, I have an appreciation of what you do in the District Court of Appeal and how that travels up through the system, how you get review in the Florida Supreme Court, the proper way to get review in the Supreme Court, the jurisdiction of the Supreme Court. That's what I do on a weekly, monthly basis. But as far as those specific cases, no, sir.
Question, you're admittedly in a kind of a supervisory role now with the number of attorneys and the number of cases, and obviously you can't do everything yourself. Just out of, for information purpose, how many cases, appeals have you personally handled since taking over as bureau chief, where you've had substantial input to brief writing or actually arguing cases before the court?
Admittedly, not as many as I did before. Early 2008, I take office. I think initially I probably kept too many, and was advised by my boss that part of the supervisory role is to not be attorney 100% and supervise, but to lead and mentor the others. What the advantage I get as being bureau chief is I get to pick and choose. If there's a difficult state appeal that's there that we need to go to bat for, it's going to be a bit of an uphill battle, I assign that to myself. Casey Anthony, when it came in, I knew that would be high profile. Nothing in that case was going to get done without going through Tallahassee and some of the discussions that would be held with Tallahassee. Instead of handling that second and third person, I assigned that to myself and took that. The Shelton case, when the Middle District declared our drug statute unconstitutional, it was not my case in the Middle District. I assigned that to myself and handled that to 11th Circuit. So, what I've done is handled the more high-profile cases, I think, dealing with state attorneys on some challenging cases and some issues that we want to see that are happening regularly on a trial basis and bringing those up. So, that's what the opportunities as bureau chief that you get.
Could you tell us what happened? You indicate that you applied to the 7th Circuit bench in 06, 07, 10, 12, and 14. What happened with those applications?
I've applied to the 7th Circuit. This is the first time applying before this committee. I've been fortunate to be nominated by those. Interestingly enough, one of the questions I get from the JNC and the governor's office, and I've gotten good feedback from the JNC because I've been selected. I've gotten excellent feedback, not only directly but indirectly from the governor's office. But one of the questions or one of the points they make is, you're applying for the trial bench. We think you'd be excellent here. You look at the outside activities, administrative skills. You bring those to the process. But this is basically an even more impressive appellate resume, and you'd be an asset to that court. And have you ever considered that? So something was created, and here I am.
On the civil side, let me ask you a question. I'm Mike Sasso, thanks for coming in. What is your feeling about summary judgment? And let me just be blunt. The reputation of this court is they rarely see a summary judgment they like. And how do you feel about summary judgment?
Well, I mean, no court, I think, no appellate court courts generally frown upon summary judgments if you want to give the person the opportunity to have their day in court. But if you don't meet the threshold, you don't meet the prima facie, you don't walk through that door and meet that initial, if you've won the case below and you properly won that case below, I mean, usually I'm in the chair position of an appellee, and if the trial court's done its job, then I'm not opposed to affirming that, but again, it depends on the facts of the case and the applicable law.
You're familiar that the standards are quite different between Rule 56 and Rule 1.510, federal versus state. Do you have any thoughts about whether the state rule should be, made more analogous or relaxed to get a little closer to Rule 56?
I don't, and that was something I would have to be more familiar with. I mean, I'm quite familiar with how we change rules and how we go to the court system and in the criminal arena. There's several things that I would like to see the state of Florida parallel with the feds, and we just recently adopted the Daubert standard for the admissibility of scientific evidence. And that's something that I think we could have done years and years ago, and some state attorneys would potentially disagree, but I think once we iron it out and have some consistency there, it would be beneficial, but no, I'm not.
Thank you.
Just looking at your application and trying to have them all be consistent as folks come through here. 18A asks for schools, class standing, dates of attendance, and degree. And you have class standing on one, Valdosta State College, the University of Florida College of Law, you have unknown. Can you help fill that in for us?
I do not know my class standing. I know I was not in the upper tier. There's certain awards given there. I've never had pursued that, and obviously almost 30 years ago, and I don't know the answer to that.
You give me an estimate?
No. Again, I don't think I was in the upper portion, but no, I don't. When you come out, you practice. I've done that. 1997, board certified, been 80 rated since then. I don't know how many people, the applicants before you were board certified in appellate law, but I'm one of those, and I'm quite proud of that. I run an office of several people that have that qualification, but to reach that, to retake that certification process, something I'm very proud of. And again, when you look at what the opportunities given to someone in the office, and the complexity of some of the cases handled, when you look at the degree of federal review of something that was done in Shelton, and realize when that case first came out of the Middle District, and I got calls saying, federal court binding on state courts, the answer is no. But the fact that there were a lot of prosecutors that didn't know that, I prepared a memorandum that went to every bureau chief throughout the state and bullet pointed the fact that, yes, this is persuasive authority, but this is not binding on us. And then came up with the reasons why. Because then we had, say, a Miami judge who had first appearances with a lot of drug offenses. I'm telling them this would go through the system. Next thing I know, he's dismissing charges left and right down in Miami because the drug statute is unconstitutional. Every single case was affected. Kind of a scary thought from a citizen's point of view, but that is the experience I have.
You disclosed on your application that you were charged with driving under the influence back in 1983, a long time ago. Can you tell us about that and what happened in that situation?
Sure. I was in undergrad, came home to, I went to high school. North Florida is very rural, if you're not familiar with that. High school is about 25 miles away. 100% my error, went to a friend's house, watched a baseball game, drank too much, driving home, got pulled over. Went to the county judge in the county, entered a plea, and he wrote a letter for me to get into the University of Florida, and was supported the process, but obviously a stupid and mistake on my part, and a mistake that I've lived with ever since, but been successful in the Attorney General's office and had a lot of accomplishments since then, but just a stupid, beautiful mistake.
How old were you back then?
19, 20, it's back when you could drink at 19, yes sir. Almost 30, well, over 30 years ago. So,
And nothing
no,
after that.
no.
How does your job differ from, I mean, you've been under several different attorney generals now. Does your job differ?
In the big picture, no. I started with, the Attorney General goes by General, so General Butterworth initially, worked under General Christ, General McCollum, and now General Bondi. Criminal appeals, when I went up to interview for Bureau Chief, the deputy, had just met with Deputy Shevin, Attorney General Shevin, and then his deputy at the time, and had talked about the core mission of the Attorney General's office in Florida was going through some pretty challenging budgetary issues. And I think they were trying to see what was needed, what was most important, and prioritizing. So it was my take on what they were doing. And, if you look at the Florida Constitution, the very setup of the Constitution, the Attorney General's office, one of its primary functions is criminal appeals. And we've been lucky enough that, from our office's standpoint, that we're allowed to practice and represent Florida regardless of the Attorney General's office with their support.
Does anybody have any other questions? Okay. You may close.
Okay. I'll close like I began. What do I bring unique? I think you'll be hard pressed to find someone with the breadth of appellate experience. People who've handled appeals, but literally, petitioner, respondent, appellee, appellate. I've handled thousands of cases in this court, argued here numerous times. So I understand that the practice before the Fifth District Court of Appeal. I understand the questions about civil, but when you look at what this court primarily does, again, it's 5,000 cases. 75% of what they do is criminal post-conviction, a lot of pro se. I've handled those on a daily basis. And in the civil arena, I understand the standard of review. If you need an efficient attorney to come in and be an efficient judge that understands deference to the legislation, following the clear words of the legislature, following the precedent, that's what I do on a daily basis, and I would bring that skill set to this court. I think when you look at the court and the judges here, balancing that out with what I bring to this court, will be an asset to this court, and I hope to be given an opportunity to make that point to the governor in his office. Thank you.